What's up, everybody? I want to come to you today with episode 13 of Police Stop. Now, today we're going to take one more step into the differentiation between probable cause and reasonable suspicion, because we hold them to a standard of probable cause because that is what an arrest is. Reasonable suspicion is something where they still have to articulate, and it has to lean towards probable cause. And that's what we're going to get into today. So let's go. During a police encounter, one of the things they always say is, well, I have reasonable suspicion to conduct this investigation. That is true. If they have reasonable suspicion that can be articulated to conduct an investigation, they have to articulate it. Now, reasonable suspicion, the standard is low. But when we're talking about probable cause, because we're going to go into reasonable suspicion, but probable cause itself, as in United States versus Socolo, probable cause means a fair probability. When you're talking about a fair probability, it goes into the fact that a crime was committed. There are facts that stipulate that you could be or are the perpetrator of said crime. Now, even if there are elements available, now we still are in Terryville, Ohio, as regards to the stop itself. So with this one, we're looking at the fact that now probable cause has to be available prior to a search, even a pat down, for a warrant to be obtained. So if that's not available to them, or actual facts for those aren't available, then they now have to do their job properly in order to obtain that. Whereas Beck versus Ohio, the court stated that probable cause was based on whether an officer had knowledge based on facts and circumstances that provided them with reasonable, trustworthy information that was sufficient to form the belief that the person arrested had committed a crime. Again, it is something that had to be articulated and is something that allows them to get the warrant to move forward. Now, if you were to go look for court cases regarding reasonable suspicion, you won't find very many, because reasonable suspicion is not part of federal law or the Constitution. So how is it able to be used? And the biggest issue was the standard for reasonable suspicion was brought up, coincidentally, in Terryville, Ohio. And with Terryville, Ohio, it gave you the diagram for how police procedure is led on and what they're able to do and when they're able to do it. And it has a step-by-step guide in order for them and you to stay protected and to do jobs properly. And again, just as Terryville, Ohio stated, that even a pat down requires articulation and being able to show that the person that they are patting down for their safety has a weapon. And you flat out ask them, do you believe I have a weapon? If they say, I don't know. I don't know is not a proper answer. I don't know is not articulation. I don't know does not offer them authority to do a pat down or consent. Because when we were talking about a pat down, an officer that says, well, I'm doing it for my protection, I don't know. Well, even a protective search, the officer must have reasonable suspicion that the individual that is being frisked is armed and dangerous. That is part of Terryville, Ohio. Again, this is not my words, not my opinion. This is actual case law and actual procedures. And if they're not adhered to, again, they have the fiduciary duty. They made the choice to become protectors of law and the enforcers of that law. They made the choice to become amenable to the public. So understand, no matter how they want to construe it or how they want to imagine themselves, they are the servant. You are the master. They made a choice to be that. Allow them to do their jobs, and make them do it properly. And until next time.